Good morning, everyone, and welcome to the Data Practices Potpourri webinar with the DPO. Thanks for joining us today. As you probably noted at registration, we are trying out a new platform today. There were some recent changes to WebEx, and we've decided to give Teams a try. So we look forward to hearing your feedback about how this process and this format is working. And please be patient with us as we work through some growing pains related to switching up our format, our platform. So you know us, we're the Data Practices Office at the Department of Administration. We're a statewide resource on data practices and the open meeting law. We will have a Q&A session today, of course, but we respond to questions every day about these two laws, so please reach out as you think of them. The other thing I'll note is that the legislative session is coming up, and we are happy to work on drafting with you, and we'll be tracking bills as usual as they move through the process, so we will be doing that. This webinar will be recorded. It's being recorded, and we'll post it on the Data Practices YouTube page. So if you missed part of today's webinar or want to go back and watch it again, or find one of our previous webinars, you can do so on our YouTube page. One of the nice features of Teams is that you should be able to click on links from the slides. So you can have access to our resources in real time. You can go to our YouTube page right now and take a look at those other webinars that have been recorded. And this one will be up in a couple of days. This is our schedule for the morning. The link on this slide will take you to the page where you registered. And if you scroll down to the bottom, you will see Data Practices Potpourri. And if you expand it, you'll see the slides for December 2025. So you can go to this link right now and get access to the slides. They're up on the website where you registered, and they will just live there. So you can go there now, or you can go there after the webinar. I'll put this link up again at the end of the webinar during the Q&A portion. The Q&A in Teams is up at the top. So if you do have a question for the Q&A portion, go ahead and hit the Q&A icon at the top of the screen, and that's where you would put your questions for the Q&A. The chat is disabled for the webinar, but we are able to post there, and we will put the CLE code in there for those of you who need that, and we'll also put the evaluation in the chat, and we really ask for you to fill that out so we can get some feedback on substantively how this is working, and also just sort of the change to Teams. So this is another installment of Data Practices Potpourri, where we highlight questions we've received from data requesters and government entities. We have had an increase in questions from government entities about some really foundational requirements of and obligations of Chapter 13 around costs and timing. And we have addressed these in previous webinars, and we talk about them during our workshops and trainings. But usually if there's an uptick in questions about a certain thing, it suggests that there's still some confusion, and we want to be proactive about answering these questions for a broader audience like the one we have today. So as I said, we're going back to basics. Question 1 is, can an entity charge for inspection? The answer, of course, is no. Nope, I'm sorry, I'm going ahead. The answer is no. 13.03 sub 3 says, if a person requests access for the purpose of inspection, the responsible authority may not assess the charge or require the requesting person to pay a fee. There are many gray areas and it depends areas in data practices. This is not one of them. There can be no charge for inspection. So that means there's no charge to search and retrieve, there's no charge to compile and review, etc. If you're a government entity and you're attempting to charge for inspection, you are not in compliance with the Data Practices Act. What is inspection? 13.03 says inspection includes but is not limited to the visual inspection of paper and similar types of government data. So inspection is a visual inspection. If the requester is asking to inspect and then describe something that is not a visual inspection, they want to plug in a thumb drive, they want to download it from Dropbox, they want to take paper copies away, that is not inspection. So if a requester says inspection but describes something that's actually copies, then of course entities may charge. But if they just want to come in and look, it's going to be free. We have a long-standing advisory opinion here. Again, you should be able to click on links that says that requesters can take pictures for free since they aren't asking the government to make a copy, and it's a part of the way that they're inspecting the data. The exception for taking pictures during inspection is for law enforcement agencies related to unredacted body camera data inspection. They can't take pictures of that unredacted body camera data based on 13.825 for those of you that work with that data. For advisory opinion 02036, sticking in a thumb drive, aside from possible security issues, is a requester taking the entity's digital copy away, and that goes beyond inspection. So again, inspection is free and don't charge for inspection. Question 2 is another evergreen question, a basics question. A data subject requests data about themselves. How long does an entity have to respond? The answer is immediately or within 10 business days. This is, as we've talked about before, an unforgiving provision. There are no exceptions, and there is not a way to cure a violation once you are on day 11. 13.04 says the responsible authority shall comply immediately or within 10 business days. What does comply mean? It means provide access to the data. Does not mean acknowledge the request. It does not mean ask for clarification on day 10. That said, we understand that we are living in a time where there's more data than there's ever been. And that means there are times where getting data to a data subject in 10 business days is not practically possible. So what can you do? What can entities do? As you know, as I'm sure you're doing already, data subject requests go to the top of the list. If you're not sure what they're asking for, get clarification on day 2 or 3. Don't sit on it and wait till the end of that time. Data subjects are going to assume that the clock is ticking when they hit that submit button for their request. You likely have a general idea of what data subject requests look like for your entity based on the services that you provide. And you may be able to provide educated guess around what it will take to fulfill the request. So communicate that to the requester. Have a conversation about it. It may help you to reduce the request or allow the requester to understand where you're coming from and the time it's taking. Try to provide some data in 10 days and at the same time a schedule for going forward. So if you can't provide all the data, provide some data within 10 days. Again, if you're outside the 10 days, technically you are past. Communicate a timeline if you can't comply fully. Most requesters want the data, and if you are reasonable in providing it, most requesters will be reasonable in accepting it on a timeline or rolling basis. That said, the statute is clear. Once an entity is beyond the 10 days, it's out of compliance, and if a data requester can show that non-compliance has damaged them, they can seek the civil remedies under 13.08. So I always like to remind folks that initially this was a 5-day turnaround time. It was expanded to 10 days. It's stayed at 10 days for many years now. But that is the number that we currently have. I'm going to pivot now to some questions raised by recent legislation. As with any changes, especially entirely new provisions, there's likely room for improvement, meaning there's likely room for differences in interpretation. And being closer to the passage of new laws means that we have a better idea of what they were trying to do. But in general, when we at the Data Practices Office are answering questions, we're looking at the language first. And if there is a clear result based on the language, we go with that over intentions and policies. So wading into a tough one, expungements. Can a data subject get access to data maintained by a law enforcement agency if the offense was automatically expunged by the Clean Slate Act or automatically expunged by recent cannabis laws? The answer is yes, the data are private. In the Clean Slate Act in 609A.015, data on a person whose offense has been expunged under this subdivision, including any notice, are private data. And for the cannabis auto expungements, 609A.055, the data on the person whose offense has been expunged are private. So unlike petitioned expungements, where there's a court order sealing the records, automatic expungements are explicitly classified as private. This means that the rights and responsibilities around private data under Chapter 13 apply, and the data subject may get access to the data and consent to its sharing. The data may also be shared when statute allows for the sharing of private data, and this is different than a petition expungement where the individual whose offense has been expunged cannot get access to the records held by law enforcement agency. I want to note that the cannabis laws also provide for petitioned expungements, and those work differently. The ones that I'm talking about here in this question are the automatic expungements. As a follow-up to that, if a requester that is not the data subject requests access to a record that has been automatically expunged, how should a law enforcement agency respond? So section 13.03 subdivision 3 paragraph F requires government entities to cite the statute classifying data as not public and therefore the reason for withholding access. So for automatic expungements, that means citing to those two provisions that I had in the slide previously, 609A.015 for a clean slate or 609A.055 for automatic cannabis expungements. We recognize that citing the statute may frustrate the intended purposes of these two laws. By classifying data as private, the legislature imposed the structure and administrative requirements of the Data Practices Act on these data. That means an entity must cite to the statute when they deny access. It's our understanding that there are some efforts currently underway to address some of these inconsistencies or misalignments of these new laws with Chapter 13 so that they accomplish their stated purposes. And so that government entities can have a clearer and consistent way to administer these expunged records. Until then, government entities should treat these specific automatic expungement data as private in the same way they administer all their other private data. We've also received a number of questions about the recent changes to the body camera section, which now allows certain individuals to get access to body camera data while an investigation is active. So a newer provision in section 13.825 allows for access to unredacted body camera data while the investigation is active if the requester is entitled to a copy of the state accident report. Who gets access? Who are those folks? So the following individual and their legal counsel and insurance representatives who have access to the state crash report can also have body camera video. And that's any individual involved in the accident, the representative of the individual's estate or the surviving spouse, or one or more surviving next of kin or a trustee appointed under this particular section. And also any other person who's been injured in person, property, or means of support, or who incurs pecuniary loss can also have access to the state crash report. And they can have access to unredacted body camera video if they are pursuing a claim related to the accident. So even if the investigation is active, those individuals that have the state accident report and are pursuing a claim in court around the accident can have access to unredacted body camera footage unless there's a compelling reason that providing access would interfere with an active investigation. And in that case, the law enforcement agency needs to provide a written reason for the denial and notify the requester of the remedies in 13.82 subdivision 7, or if the data are clearly offensive to common sensibilities, or if the data are classified as not public by other provisions under this chapter. A law enforcement agency must also notify requesters receiving body camera video under this provision, so they have the state crash report, and then they're getting access because they're pursuing a claim, that they are subject to the remedies and penalties of section 13.08. So when providing access to the video under this provision, law enforcement agencies should provide a notice that the video may only be used to process a claim related to the collision or evidence in a proceeding related to the collision. The requester must not disseminate the data or use the data for any other purpose. So you want to provide that notice so that when they're receiving this unredacted body camera footage, they know what they are allowed to do with it. Another newer state law starting on January 1st, the new Minnesota Paid Leave Program, begins on January 1st. The program is administered by the Department of Employment and Economic Development, DEED. So the question related to that is, can a government entity employer provide private personnel data to the Department of Employment and Economic Development to confirm that an employee is eligible for the new Minnesota Paid Leave Program? So DEED has statutory authority to share private data about an employee's application with employers. So when an employee goes to DEED and is applying for this new Minnesota paid leave program, their data are private at DEED, but DEED is going to reach out to the employers to ask for information. Government employers must have consent from the employee before disclosing private information that confirms an employee's eligibility. To learn more about this program, both for employees and employers, you can go to the website, the link on this slide. I know entities have probably been preparing for paid leave for a while, but we wanted to flag this particular data practices issue so you can incorporate some consent management practices into the process so that you indeed can process applications efficiently. So for those of you who work in data practices and maybe your HR folks aren't on this call or this webinar, reach out to them and just let them know that they will need to have consent to kind of have that back and forth with DEED and to make sure that gets done, because I think there's kind of a short turnaround program for the decisions to be made around that. So just flagging that as a data practices issue for your consideration. My last question today, the most hard-hitting, is where can I get a copy of the 2025 Data Practices Laws and Rules books? For those of you who have been doing this work for a while, you probably recognize this. You can get it at Allegra Printing. Again, you should be able to hit this link if you are used to working out of this book. They are available now, so you can get one if you would like one. Right. And just as a reminder, these slides are available with links and all of the information. So we're going to turn now to the Q&A portion of our webinar. Again, the Q&A icon is at the top. You hit that, you put your question in. When your question is answered, I believe everyone on the webinar will be able to see it in the Q&A panel, so you can see which question is being answered. If we don't get to your question today, of course, we'll follow up afterwards with you. Again, we're here to answer questions anytime, not just during this Q&A, so please feel free to reach out to us. Slides are available as noted here. You can hit the link. Again, the recording is going to be here. I will put the evaluation in the chat panel. It's a Microsoft form. Please fill that out. Let us know what other types of webinars we can do or resources that would be helpful to you. Feedback you have about Teams versus WebEx. That will all be very helpful to us. And I'm going to take a pause and turn it over to the team to start answering the questions.
One really quick note here. We haven't seen a lot of questions come through quite yet, but I did see a few hands that were popping up here and there, which suggests to me maybe there were some questions. And so if you are having some issues with asking a question, if you go to the Q&A panel, I think it kind of starts out as start a discussion next to your initials there. If you click on that right kind of, I think it's a speech bubble, and then go down to ask a question. That should allow you to enter some information and ask a question, whether it's anonymously or however you want. And so just giving people that little tool tip in case that is preventing folks from being able to ask questions.
And just to follow up on that, within that Q&A panel, that's also where we'll drop information on the CLE code. I've dropped it once, I'll drop it again in a second, as well as the evaluation link because chat is turned off. So you should be able to find everything you need in that Q&A panel there. Thanks.
Okay, the first question that, excuse me, that we have here is requiring prepayment for body camera video acceptable? Generally, yes. I think requiring prepayment is certainly acceptable. One of the things that you'll want to do is make sure that you have that documented in your data access policies. Typically, body camera data are going to be data subject data, so there's not going to be a whole ton of that you can charge. Because you can't charge for that search and retrieval, you can't charge for that redaction. Of course, you can charge the actual cost to make the copies, and so any sort of device that you put the copies on, mailing costs, those types of things, you can certainly charge. So yeah, requiring prepayment is totally fine. There is no exception for body camera data where the law says you have to wait until you've actually provided or are ready to provide the data to provide access. My suggestion, just make sure that you have those prepayment requirements in your data access policies for both members of the public and for data subjects, which are required under 13.025.
Okay, so we had another question about the clean slate and cannabis automatic expungements. So public asking for these records are not entitled to them. If we state the statute for not providing the info, we are confirming the data exists. Yes, that is sort of a challenge with these sort of automatic expungements, is that, you know, with an expungement, another kind of expungement done through the court process, you're really not, when someone asks for those data, you're not off, you shouldn't be providing information that the data exists at all, usually, because that expungement is sort of sealing that record, right? But the language in these automatic expungements doesn't seal records. It's actually a private classification. So we have to sort of give that language effect in the Data Practices Act. And under 13.03, subdivision 3, we do have to cite the provision that we are relying on to withhold the access. So we're treating these automatic expungements as private data per the language in these automatic expungements statutes, which does mean that we're providing that citation and confirming that the data do exist when withholding access. So it is treated differently than other types of expungements, yes.
Okay, another question that we have here. Can we wait to start redacting until the prepayment is received? I assume this is also in relation to the body camera aspect, but I think this counts for all data. Yes, I think, again, you'll want to put that in your data access policies. Just clarify that, you know, before you'll begin the work and kind of start processing the request, you know, you do need to receive the prepayment. Again, when it comes to prepayment, you know, I think it should be reasonable on that front. And so, yeah, I think probably saying, communicating with the data requester, confirming that you've received the data, that you'll begin working on it once prepayment is received. I think that's all a reasonable process contemplated by the Data Practices Act.
All right, next up, we have a question that says, when laws change, where's the best place to see all of the changes? For example, the body-worn camera statute this past August. So you're really going to want to go to the reviser's website, which I can put a link here. This just links to 13.825. Right now, it's all up to date because the changes have been made. Before the reviser gets those changes into the actual statute, there'll be links at the very top of the statute that link you to the legislation where the language has been changed. So that will take you directly to the language in the bill that was passed. And that's really how to see the language before it's incorporated into the statute. And then we also, if it's a data practices law like 13.825, we do try to update our website to flag those changes right away as well. So you can always check out our website, but the reviser's office is going to be the best place to look for that.
Okay, another question here. I'm just going to be the 13.025 person today, I think. If a data request needs to be clarified, requester is contacted and requester does not respond, can the request be considered abandoned? For example, the request uses terminology that does not align with data held by the entity, and clarification of terminology is necessary. Yeah, I think that's reasonable, but again, I would put that in your data access policies, simply saying, hey, this is how we're going to be processing data requests. If we have questions or confusion and need clarification, we will follow up with you. If you don't respond to that clarification, then we will, you know, consider your request abandoned, you know, within a reasonable amount of time. And so, you know, I think what is reasonable is going to vary for each agency. What's not reasonable, probably if somebody doesn't follow up with you within 24 hours, probably not reasonable. You know, I think admin's policy maybe says 14 days or 15 days. If we don't hear back from you, we'll consider your request abandoned. So maybe that's the amount of time, maybe a little bit longer. But again, put that in your data access policies that are required under 13.025. But yeah, I think you don't simply have to wait for years or months even maybe to just simply have somebody get back to you and assume that they still want the data if they just kind of fall off the face of the earth and aren't responding to your questions. But again, I would put that in the data access policies.
I'll hop to another automatic expungement question. So this question asks how to handle requests from the FBI on the automatic expungements. Are they included with the Minnesota state agencies included in 13.82? So automatic expungement data will be treated as private. And so private data can be shared with other entities, including federal agencies, if there's statutory authority or consent to share. So for a request from the FBI, if they're looking for, say, some law enforcement data that is part of this expungement, you would look to see if there's statutory authority to share. And under Minnesota statutes 13.82, you do have authority to share with law enforcement agencies under subdivision 24 if that data is pertinent and necessary for that agency for initiating, furthering, or completing an investigation not related to except not public personnel data. So I would take a look at that and see if the FBI is involved in an investigation, if these data are pertinent and necessary for that agency. There is some statutory authority to share that private data there. But if it's just a blanket request, it's not specific to law enforcement investigation, they don't have authority under 1382 just to receive any expunged data. I think it has to be tied to some sort of law enforcement investigation there, but there is some statutory authority that you can look at for those types of requests.
Okay, another one that we have here in reference to body-worn camera and 13.825, what's an example of data that would be classified by other provisions under this chapter? It's a great question. I don't know that there's a one size fits all, but you are asking for an example. So maybe one might be, let's say an officer has a body camera on and it captures the officer accessing active criminal investigative data, or going to the computer in the squad car, typing things in, and then clearly in there you see maybe a protected ID under subdivision 17 or other information on that computer screen that would be clearly classified as active criminal investigative data. I think those are the types of things that you would be, redacting out and protecting. Kind of some of those other things that maybe the legislature hasn't necessarily considered, where you're capturing other data or other aspects. So that might be one example. If you are thinking of a particular situation or saying, hey, we're trying to figure this out, certainly reach out to our office and we can talk through that with you on whether or not that kind of catch-all language applies. But I think that's the best example that comes to the top of mind for me is, if your officer happens to be catching something that might be on a computer screen or on a desk that's clearly not public data, you can probably redact in that situation.
All right, next up, we have a question that asks, are local governments allowed to charge for redaction and search for data and records? So under the Data Practices Act, government entities may not charge for redaction. They cannot charge for the time spent to separate private data from public data. Whether the government can charge for search and retrieval will depend on whether the request is made by a data subject or a member of the public. So if a data subject asks for data about themselves, then the government cannot charge for time spent searching and retrieving those records. If a member of the public asks for public government data, then the government entity can charge for the time spent searching and retrieving records. And we have more information about this on our copy cost page. So I'm just going to drop a link there in case you want to refer to it later. Thanks.
I did drop a link to the evaluation in the Q&A panel. I pinned it, so it should be at the top of those questions. So hopefully you can all see that link. I wanted to give you a few minutes to be able to fill it out before our time concludes, so it is available for you there. We appreciate all of your feedback. Thank you.
All right, I am going to slide in here one more with another, probably my final question. Can you clarify the body camera data or body camera rules related to crash accidents per the statute if the individual requests a copy of the recording? Data on other individuals who do not consent to its release must be redacted from the copy. So it's a good point. And what I think that language is coming from is 13.825 subdivision 4B. And so that's a little bit different than paragraph C. And so subdivision 4C really is what's governing the unredacted body camera data related to crash investigations or accident investigations. Subdivision 4A and B really talk about any other sort of data request for body camera data. But when it comes to crash investigations, you're really going to want to be looking at C, and that does allow someone to get unredacted copies of body camera data when they're also entitled to a state accident report. So that's the big distinction there.
Thank you very much for all of those great questions. And if we didn't get to your question, we will reach back out to you and answer them. Thank you for joining us today. Please watch out for registration for our next webinar. It's going to be in late January. It's going to be all about the open meeting law. It will be a little bit longer. So if you have questions or would like to see a presentation on the open meeting law, watch out for that. Please